This is a review of Unit 7 of AP U.S. Government and Politics entitled The Federal Judiciary. We actually live under two sets of law here in the United States since we are a federal system. We have both federal laws and state laws, and thus we have both federal courts and state courts to enforce or implement those laws. The federal court system hears cases of individuals who have been accused of violating a federal law, like tax evasion or threats of terror or various other instances. However, the majority of people who go into a courtroom are going into a state courtroom. This is somebody who's violated a state law. Over 90% of cases in the U.S. today actually go to state courts, whether they are criminal cases or civil proceedings. The organization and hierarchy of the court system depends on whether you're looking at the federal system or a state system. Of course, in the federal system, the U.S. Supreme Court is the highest ranking court. If you go to individual states, some states have 3 and some even have 4 different levels of courts as you make your way up the appeals process. Take, for example, on your screen on the left side, the state of Missouri. Missouri has its own Supreme Court that hears the highest ranking appeals within its own state. Only if the case has made its way all the way through each of the levels of the state courts could it possibly end up in a federal court by appeal. The federal court system in the United States is comprised of 3 levels, starting with the U.S. district courts, in which there are 94 districts throughout the United States. If a case makes its way through appeal and up to the next level, it goes to the U.S. Court of Appeals, which has only 13 circuits. In a very rare circumstance, a case may make its way all the way up to the U.S. Supreme Court. It is important to remember that the Constitution, under Article 3, only stipulated that there would be a Supreme Court. Congress acted with the Judiciary Act of 1789 to create the 2 lower levels because they believed that the Supreme Court would not have enough time or justices to go through a large list of cases on their docket. The docket is the list of cases that a particular court has to look over and review. As you make your way up the federal court system, you will notice that each court has a different level of jurisdiction. Jurisdiction is the authority that a particular court has to be able to decide a case. If you start with the U.S. district courts, which are on the bottom of the chain, they have what is called original jurisdiction. This means that they are hearing a case for the first time. If the defendant believes that they did not get a fair trial or something according to due process was violated, they could file an appeal, which requests for the higher court to re-examine their case and possibly give them a new trial. If indeed they are granted their appeal and given a new trial, it would go up to the U.S. Court of Appeals. That is why the U.S. Court of Appeals is considered as having appellate jurisdiction. Appellate jurisdiction is being the court that has the authority to hear on a case that has already previously been decided on and eventually has been appealed. Then, of course, there's the U.S. Supreme Court, which we refer to as the court of last resort, because there is no appealing once it gets to the Supreme Court. The Supreme Court could have original or appellate jurisdiction depending on the case. As previously stated, the Supreme Court of the United States has both original and appellate jurisdiction, though the majority of their cases do fall into the category of appellate jurisdiction, as over 90% of them have been heard by a lower court either at the federal or state level. There are a small percentage of cases each year, however, that do fall into the category of original jurisdiction, as the Supreme Court is the first court to hear those cases. Some examples of cases in which the Supreme Court would hear it first include territorial disputes, say for example if New York and New Jersey were disputing territorial boundaries, or a case in which the executive of the United States was in dispute with the legislature. For example, the case of the United States versus Nixon, which went directly to the Supreme Court for a decision. Whether it is a federal courtroom or a state courtroom, they both have the ability to try either criminal cases or civil cases. A criminal case is a case in which a person has been indicted or charged with a crime by a grand jury of their peers. In turn, witnesses are issued subpoenas and made to come before the court and testify about what they know. A judge or a jury may determine the verdict and possible sentencing for the defendant if they are convicted. The sentences can vary depending on the state they're being tried in or if it's in a federal courtroom. Civil law, on the other hand, has nothing to do with crimes. It's actually when one litigant, an individual, sues another over money that they've loaned out or damage to their property. There's also a division of law known as tort law, in which people can sue for the wrongdoings that other people had, even if they were not intentional. A judge or jury would then review all the evidence and decide whether or not damages should be awarded to the person if they believe that guilt is found on the part of the defendant. Proving your case is very different whether it's criminal or civil law. In criminal law, the burden of proof is pretty extreme, beyond a reasonable doubt. This means that all of the jurors must come to a unanimous decision that the defendant was guilty of the crime if they're going to return a guilty verdict. That is because in the United States of America we have the presumption of innocence. Civil law doesn't require such an extreme burden. The burden of proof in a civil case is simply a preponderance of evidence. This means that the judge or jury just has to simply believe that there was enough evidence stacked against the defendant to make them look like they may owe somebody money. If in fact they believe that the evidence adds up, they will award damages to the plaintiff. Whether deciding a criminal case or a civil proceeding, it is important to understand what the legal process is in a given country. Here in the United States and in other developed democracies like the UK, our legal system is based on the idea of common law. That is, that decisions that were made in previous cases could actually set up as an example for how future cases should be decided. In legal terms, we call that establishing the precedent. A precedent is a lasting legal principle that has stood up through the test of time based on an old decision that guides future decisions. In other countries, they use what is called code law, such as in Russia. Code law disregards previous decisions and actually makes a strict interpretation of all laws based on what is written. There's very little wiggle room, as they do not consider what may have happened in other related cases. The job of our legal system, whether it's at the federal or state level, is to ensure that the principle of due process of law that is written into our Constitution is abided by whenever an American is accused of a crime. There are, however, two types of due process that have to be protected. Procedural due process is the idea that every person's steps of the legal procedure are followed if they are ever accused of a crime. Is the person given the right to speak to a lawyer? Are they informed of their rights? Are they given a fair trial? These are all parts of the procedure of due process. Then there's substantive due process, making sure that no one's personal biases were involved in implementing due process and making sure that everyone's rights were not violated. No one's personal take on someone's race, religion, gender, or anything else should impact whether or not a person is given their full due process rights. Let's look at an example that applies to school. Let's say that two teenagers get into a fight in the locker room. If the two boys are given the opportunity to go forward and tell the principal their side of the story, and they are both given a 3-day suspension, it would then be investigated into how they reached that determination. If we find that one or both of the boys was not given an opportunity to come before the assistant principal or principal and give his side of the story, that would be a violation of procedural due process, since one or both of the boys had one of the important parts of their investigation left out. But let's say, for example, both boys were given an investigation, but the boy on the left lives in the community of one of the assistant principals. Let's say that that assistant principal doesn't care much for that boy and allowed his bias against the kid to impact the way he decided to punish this boy. Then we would say that even though every part of the procedure was followed, there was a violation of substantive due process, as the personal feelings of the assistant principal got in the way of a fair trial. Article 3 of the U.S. Constitution created the highest federal court of the country, the U.S. Supreme Court. The U.S. Supreme Court's main responsibility is to interpret and review laws to make sure that they're compatible with the U.S. Constitution. Presently, there are 9 justices serving on the Supreme Court, and that number has remained intact since 1869. The Constitution gives Congress the authority to control this number. Once a member has been appointed by the President and confirmed by the Senate, they serve a lifetime term on good behavior. On the bottom right of your screen, you will see the composition of the current 9 justices on the Supreme Court. It is actually historic to see the current composition, as for example, there are 3 women on the court, and there have only been 4 all time. On the top row, you see Sonia Sotomayor to the left and Elena Kagan to the right. These 2 are the most recently added members appointed by President Barack Obama. The first and only other woman to serve on the Supreme Court came back in 1981 when President Ronald Reagan appointed Sandra Day O'Connor to be the first female on the court. Also on the current court is Clarence Thomas. Clarence Thomas is only the second African American to serve on the Supreme Court, as Thurgood Marshall became the first when he joined the court in 1967. Of course, our Constitution is all about checks and balances, and so there are various things that both the executive and legislative branches can do to keep the court system in check. For example, in terms of the President, he of course has the power to appoint all federal judges, not just those in the Supreme Court, but also the 2 lower levels, and he tries to leave a lasting political impact by selecting judges that match his party's political philosophy. In terms of Congress, they have several things they can do. They of course control the number of judges. They also can alter the jurisdiction of a court. They have the power to expel justices by using the same process they use to impeach the President. And they have the Senate advice and consent power, which gives them the final say on any appointments that the President makes to the federal court system. The court, of course, was given a little bit of power against the other branches as well. For example, the Constitution clearly states that Congress should never have the authority to reduce the salary of members of the court to try to influence their decisions. But of course, the court's biggest power over the other 2 branches is what we call judicial review. Judicial review is the power of the Supreme Court to rule that an act passed by Congress or signed by the President is unconstitutional. The principle of judicial review was first founded in the Supreme Court decision of Marbury v. Madison in 1803. In this case, newly elected President Thomas Jefferson instructed his Secretary of State, James Madison, to destroy papers that were supposed to go to William Marbury, a man who was going to be appointed to the federal judiciary by the previous president, John Adams. The constitutionality of the decision to destroy the papers, as well as the constitutionality of Adams deciding to appoint a member at the last minute, were called into question. Ultimately, John Marshall and his court decided that the constitutionality of acts by the President or by Congress resided in the hands of the Supreme Court, giving the court more power for all time. This is where the birthplace of judicial review began. The process for being selected as a member of the U.S. Supreme Court is laid out pretty specifically in the Constitution. The first step is that there actually has to be a vacancy that opens up by someone on the court choosing to retire or passing away. Once this happens, the President looks to the lower federal courts to try to find a candidate who they believe will be a good fit for the Supreme Court. Once they've picked somebody, they keep that name private and go to the 2 U.S. senators from the home state of the judge that they are thinking about selecting. This is known as senatorial courtesy. They're giving these 2 senators a heads up of the person they're thinking about selecting and getting some insight from those senators about how they feel about the selection. By doing this, it helps the President gather a gauge on whether or not this person will receive widespread approval by the entire Senate as a whole. If they move forward with the process, the Senate will then begin an investigation into the background of the person who's been selected or appointed to be a Supreme Court justice. They'll hold these hearings, call the individual into chambers, ask them a series of questions, and when it is done, they will go for a vote. That is where the person will either be confirmed as a new member of the Supreme Court or denied their spot. Amongst the 9 members on the court, only one is chosen to be the Chief Justice. The Chief Justice does not have to be the longest tenured member, but simply the person who is picked by the President to fill that vacancy once it becomes available. The Chief Justice has several responsibilities, including presiding over all meetings and sessions, delegating the responsibility of who is to write each opinion for the court, and overseeing Washington, D.C. or the Federal District for all of its appeals. John Roberts, appointed to the court in 2005 by President George W. Bush, is the current Chief Justice. Each court is titled after the last name of the man who was the Chief Justice while that court was in session. A couple of important courts of the past that AP government students should know includes the Marshall Court, which was overseen by John Marshall, by far the most popular Chief Justice in American history. Cases like Marbury v. Madison, McCulloch v. Maryland, and Gibbons v. Ogden were decided on his watch. For the most part, the cases that were decided during the Marshall Court were cases that established the national government's supremacy over the states. Then there's the Warren Court, overseen by Chief Justice Earl Warren, a very important court that oversaw major cases that dealt with the 14th Amendment, both for due process and equal protection. Brown v. the Board, Gideon v. Wainwright, and Miranda v. Arizona were a few of those landmark cases. Finally, students should know a little bit about the Burger Court, led by Chief Justice Warren Burger. These were cases that for the most part defined the limitations of the federal government, as cases like Roe v. Wade, Lemon v. Kurtzman, and the U.S. v. Nixon were decided on his watch. Perhaps the best part of being on the Supreme Court is that the Supreme Court is the only court in the United States that gets to select its own cases. Every one of the justices is giving us a particular federal circuit that they are responsible for. In some cases, based on the population within that circuit, some justices are giving multiple circuits to be responsible for. All of the appeals that come in from the states within their circuit, they are responsible for looking over and bringing to the discussion table. Each year, thousands of cases are appealed to the Supreme Court in hopes that they will settle a major dispute. For a couple days out of each week while they are in session, the Supreme Court goes into their meeting chambers, and they talk about each of the cases that have been appealed through their circuit. They put the cases that are most interesting on what is called the discuss list. They will sift through these cases and try to decide which ones pose the greatest constitutional questions. When it comes time to select the cases that they actually want to hear, the rule of 4 plays the ultimate determiner. The rule of 4 means that 4 of the 9 justices must vote in favor of taking a case for it to be issued a writ of certiorari. If a case is issued a writ of certiorari, that means that the Supreme Court is interested in actually hearing the case. They will order all the lower courts to send them any pertinent documents that they need, and they will contact the attorneys and tell them to start putting their case together. It is very important to remember that approximately 99% of the over 8,000 appeals that they are sent each year will not be given a writ of certiorari. If a case is one of the few fortunate ones to be granted a writ of certiorari and that the Supreme Court has decided that they will hear it, then the lawyers for both sides have to begin preparing their cases. They will submit written briefs to the Supreme Court in advance of their court date to outline what their side's case is going to be. If it's a case that involves the U.S. government in any way, the Solicitor General, which is one of the highest-ranking members of the Justice Department, will represent the government in front of the Supreme Court as their attorney. Interest groups also have a stake in what's going to happen. They will immediately begin writing what is known as amicus curiae briefs and sending them to the court. Amicus curiae stands for friend of the court. Interest groups have a stake in what's going to happen, as the Supreme Court's decision could impact an issue that is linked to their group. They will begin providing the court with important information that they think could sway their opinion. This is essentially the interest group's way of lobbying the Supreme Court, since they don't have as easy access to justices as they do members of Congress. Once the big day arrives and the attorneys stand before the 9 justices of the Supreme Court, each side is given just 30 minutes to present its case. Also, during this 30 minutes, the justices may ask a variety of questions, as there is not a separate Q&A session. That means the lawyer must be very well prepared to outline his or her case, while also prepared to answer questions from any of the 9 justices. It typically takes several months for the court to release its decision to the public. However, once they do so, the opinions are formally written up if it's an important enough case by one of the members of the court and released formally. There are 4 types of opinions that go out. Unanimous opinions are rare. This would mean that all of the justices agreed on the outcome. If this does happen, you can bet that it probably establishes a precedent. The more common thing is to see a majority opinion, in which one of the justices writes up the reasons why the majority voted the way that they did. There are sometimes things known as concurring opinions, where one member of the court may have voted with the majority, but did so for a different reason. That person may choose to write a concurring opinion. Finally, if it's an important enough issue, one or more of the justices who voted against the majority may release what is called their dissenting opinion, telling why they did not vote with the majority on a particular case. With cases that are not as high in profile, sometimes the court will just turn around what is known as a per curiam opinion. This is where the court just has a brief unsigned decision, and they don't go into the same depth to explain why they reached this decision. This is only done again with cases that don't have a high media profile or high public interest. The question has often been asked, what role should public opinion play, if any, in the Supreme Court's decision-making process on which cases they want to hear and the way they decide on those cases? The framers of our Constitution were well aware of the effect of public opinion, and thus they built several things into the Constitution to try to insulate or protect the Supreme Court justices from public opinion. For example, they gave them lifetime terms. They made them appointed positions, not elected positions by the people. They gave the Supreme Court the ability to not have their salaries altered by Congress. They also gave the court control of their docket, as they didn't have to give in to pressure on which cases to hear. And Supreme Court members are not out giving TV interviews like members of Congress. In fact, you won't even find a TV camera allowed in the Supreme Court room. But members of the Supreme Court should probably still care about public opinion if they want to get their decisions enforced. For example, Congress still has the ability to expel them if they're not doing their job the correct way. Also, they care about their professional reputation as being a good justice who actually enforces the Constitution correctly. They also know that Congress could try to get around their decisions by proposing new amendments. But most importantly, the Supreme Court knows that after it hands down a decision, that decision is only as good as it will be enforced by the executive branch. This is known as judicial implementation. Their decision doesn't mean much if it's not going to be enforced. For example, take the decision by President Andrew Jackson after the Supreme Court ruled that the Indian Removal Act of 1830 was unconstitutional. Jackson's response to the court's decision was, "Mr. Marshall has made his decision, now let him enforce it." In turn, Jackson allowed the Trail of Tears to preside, one of the darkest moments in American history, in defiance of the court's decision. Amongst the 9 justices, there are very different opinions on what their role actually should be in the policy-making process. Some justices think of themselves as judicial activists, while others would refer to themselves as judicial restrainists. Judicial activism is the belief that the Supreme Court justices think that they should have an active role in the political arena, that they should keep constantly monitoring over policies to ensure that the constitutionality is being followed. Judicial restrainists, however, believe that they should exercise a little discretion over their power and limit their influence over the policy-making process, and only intervene if they believe that something is blatantly unconstitutional. A common belief by judicial restrainists is that you should look to the doctrine of original intent to help you make up your mind on a case. The doctrine of original intent holds that when making their decisions, the Supreme Court should look to what the Founding Fathers originally intended when they wrote the Constitution. That is, that they should not be getting too open-ended with the way that they interpret the words. Then, of course, there are those who believe in the principle of stare decisis. This is the idea that you should let the decision stand. Use precedents or common law to guide your decision-making. Stare decisis is also very common amongst those who are judicial restrainists. I hope that you have found this review of Unit 7 of AP U.S. Government and Politics entitled The Federal Judiciary helpful. Good luck on the AP exam in May.